Q stands for clear and unmistakable error, and it's a legal concept that is very rare and very often misapplied. A Q claim is used whenever you want to reopen an old decision, and not just reopen it as in you're claiming service connection for that issue. Reopen it as in you guys got it so wrong. Not only am I asking to reopen it now, but I'm asking you to go back to the previous decision and undo it as though it never happened. Either grant the benefit, increase the rating, or whatever is being sought. You got it so wrong, you've got to go back and open up that old decision. So you can't file a Q claim to a decision that you've got in the last year, because you could just file an appeal then. It's not a final decision until the appeal deadline has closed. So we're talking decisions that are over a year old. I've seen decisions that are over decades old, but the important thing is it's outside of the appeal period. Because if you're within the appeal period and you disagree, they've gotten it wrong, just file the appeal. That's a lot easier, much easier to prove. You're not going to get them to turn your Q claim down because you didn't file it correctly. Got to make sure the decision is final and unappealable. This is something that even VA employees don't know. There's not a form to file a Q claim. If you're filing service connection for a particular thing or increased rating, you would file with a VA new claim form 526 EZ, or you would file with a supplemental claim form 0995. But for Q, this is such a big issue and so different from filing an actual appeal or a claim that they don't even have a form for it. I've seen a lot where it's raised or a potential option, but actual winnable, provable Q claims is a very small percentage, less than 5, probably more like 1%. They're not impossible and they're not completely unwinnable, but they are very rare and it's very specific. A lot of times there might be a different reason to reopen an old decision that is not Q, but because Q is spoken about so often and it's got that nice little snappy acronym, I think it gets misused a lot. There's other ways to open up old decisions that is not showing there is a clear and unmistakable error. The standard for what VA has to find in order to grant Q to go back and look at that old decision and say, you know what, we got it wrong. It can't be something like, well, I had a medical opinion that proved that was positive and you guys had a CMP opinion that was negative and you went with the CMP. That might be wrong and definitely something I would appeal if it was a recent decision, but it's not clear and unmistakable error. That's a difference of opinion. We might not agree with when the VA goes with a CMP over a nexus letter, but if there's reasoning involved and it's something we would appeal, it's not enough to be able to reopen an old claim. Again, I'm not saying the VA doesn't make mistakes. I'm not saying that a lot of old decisions aren't wrong, but clear and unmistakable error is such that reasonable minds could not differ, is what the standard is. When the VA does decide clear and unmistakable error claims, you can only look at the evidence that was in the file at the time of that old decision. So you can't add in new and later evidence, or even evidence that later is already in your file and it was just added later. It's not Q. It has to have been in there. All the facts as they were known at the time of the decision has to be in there, and it's that the decision maker got it so wrong, no one else reasonable could look at it and come to that same conclusion. Actual Q claims are so rare and uncommon. VA doesn't even have a form for them. There's not a specific claim form to file. In fact, a lot of times if you file what seems, VA will kick it back to you and say, you didn't list any conditions. You can legally put a Q claim in on a piece of notebook paper that you write out your legal argument on. There's not a specific form. What I would suggest and what we do whenever we find what we think to be Q claims is to prepare a letter outlining, here's the evidence, here's what was wrong, here's the claim, here's the decision. And we submit that along with a supplemental claim form, a 0995. Generally, that is enough to at least get VA to recognize that you're initiating an action. Sometimes they might call you and ask for additional information. But generally speaking, a supplemental form, claim form with either attached argument or your argument on the actual form itself. You need to let VA know what you're disputing and what the evidence is. These are hard claims. Obviously, you're going back to an old closed decision. That can result in a lot of back pay if it really is a Q and they messed up. So they're not going to really do that work for you. So you need to point out as much as you can